Good afternoon, everybody. I feel like we need a little bit of music in the background, like all is well, all is well. I'm going to switch gears, and this is a good transition, talking about too much about technology. Now we're going to talk about the process. What about when we talk about the digital evidence and the forensics, there's equal importance to not just the technology, but how the process will work, the importance of it, and why. And expert testimony when it comes to the judicial systems. I'm not going to claim that I'm the expert when it comes to the Indian judicial systems, because I grew up in India, then I moved to US. All of my education is in US. All of my experience has been in US. I've traveled around the world in many countries, did data collections, have done forensic testimony both in US and Canada. Have a lot of formal training as well. And just wanted to share my experience, and thanks to Vinayak sir and everybody in the team to invite me to speak. What I'm going to start with is the need of digital forensic expertise in litigation. US compared to India is a much more litigious state, litigious country. Anything you can claim, any kind of disputes, it always goes to litigation. The discovery request goes out for many, many years, and it's not easy to get past the court system or as quickly. So the need for digital forensic expertise is one. These days, anything we touch, anything, even when we are not looking at our phones or computers, it's generating data, and it's multiplying in many different ways. And digital forensics comes in play in almost any kind of investigation, whether it's a civil or criminal. So having a need of an expert who can understand not just the technology, but how the rules may be applied, and being an impartial voice to whatever happened and represent the facts to the judge, it's very, very important. To give some examples, let's say if there is an employment issue or there is a theft of trade secret issue, hiring an independent expert gives a voice to the company that this is not done by somebody in IT who may have some bias against some employees, or there may be CEO or C-suite people are forcing them to do something certain way. Instead, if you are retaining an independent expert, a digital forensic expert, then they can do as by the rule of law and everything that needs to happen after that. The digital forensic experts would also have the experience that is required for what is expected when the questioning comes from the other expert. So generally in the US court system, if you are a plaintiff's expert, there will be another expert on the defense side as well, who can look at your report, who can look at your findings and write a rebuttal. Or in a very, very complex situation, even the judge sometimes appoints or uses his own help and appoints an expert to see what may be going on. So mitigating those potential issues ahead of time is very important. And also the courtroom experience is a big plus. As before you qualify to be an expert in the courtroom, you'll be questioned in many different ways about your qualifications, why you are called the expert, what is your education background, how many times you have testified, in what manners, and things like that. So There are a couple of types of expert testimony when it comes to digital forensics. One is testifying in writing, and the other one is testifying orally. In writing, it can be in a declaration format or affidavit format, or as an expert report format. Generally, depending on the type of litigation, you're working with outside counsel. The attorneys are, they would direct you which way they want or which way they prefer. If it's just the expert report, then you note down the process, what you collected, how you analyzed, what tools you used, and if there is an opinion or if there is just a fact base. The declaration and affidavits are more fact-based compared to the expert report. You can have a conclusion. You can have a small, I want to say, based on your experience, this is what you've seen before, and this is what you think may have happened. So it really depends on the type of the investigation that's needed. In oral testimony and deposition, that's really when you have an opportunity to talk about the work itself, and the other side, the attorneys and the forensic expert, to ask you almost any kind of questions they can ask and poke holes in your process, try to discredit you, try to make the say things that you wouldn't want or you wouldn't want to say, or say it otherwise, and especially in the courtroom. In order to get admitted to a courtroom testimony, they'll grill you on the stand and prepare you before ahead of time in many different ways. Just a couple of slides about the U.S. court system. The federal versus state courts. There's a Supreme Court at the very top. Right below it, it would be the Court of Appeals. Right below it would be the U.S. district courts and federal courts. Depending on the type of cases, you start with the state courts and move to the federal court and then Court of Appeals, where a panel of judges might sit and look at the very complex cases. If you're following the news, especially about the FBI raids on Mar-a-Lago and some other places, almost all these courts go through step by step, and there is a process, and there's a forensic experts at every single step. And in that specific case, there is the judge-appointed special master and neutral expert that plays a role as well. Something that can be easily Googled, so I'm not going to spend too much time on it. This one I came up with this morning only. It says karma is real, and so is expert testimony. The reason I say that is your expert testimony, whether it's in writing or oral in the U.S. court system, is discoverable. That means anybody from a month from now or 5 years from now or 10 years from now, that record and what you said in writing or oral testimony will always stay there. So if I opine on something today, and 10 years from now, if I'm testifying on a similar subject, the attorneys can pull up the record and say, well, Mr. Oza, you said something like this 10 years ago. What happened? What's changed? So if you are forced to say something just because your client wanted you to say something, it can come and bite you, eventually. So you have to be really careful about what you say and how you say it. A good testifying expert would know where to stand up and say, no, this is what it is. This is how I'm going to say it. Take it or leave it. So it's very, very important. Some other things I wanted to share, especially just based on my experience, is how the messaging is happened. Of course, you as a digital forensic expert, you know the technology, you know the process, but it's as important as how you convey the testimony. The judge is an expert in the legal aspect of things, being a neutral and in a variety of ways, and has controls over what he can or cannot do. But it is very important about how you lay out the facts to the judge or the jury so that they can understand this is exactly what happened, taking out the technology out of the way, but still keep it fact-based and evidence-based. So it is very important. Also, in my experience, the quality over the quantity when it comes to the reports or testimony, the less is more. You want to be as direct as possible, and stick to the facts, not just talk about everything that you may have done, but only what may be important and what are your strong points about the investigation, and not point out a lot of the weaknesses, in other words. Some of the judges that I've worked with and my colleagues I've worked with, in my experience, can get bored very easily if you just keep talking about the technology over and over, or keep repeating the things that they may not want to hear over and over. So sometimes building a goodwill with the judge, especially in the courtroom testimony, is very important. The courtrooms are, the schedules are very much backed up. The trial dates are 12 to 18 months ahead of time. And when it's your turn, all they want to hear you is facts, facts, and facts. And you as an expert, you have the obligation to stick to the facts and move on. So building a relationship with the judge in the courtroom is very important. And it also helps with your credibility as well. The last point I mentioned is recovery and exit. So as an expert, you always want to leave out a little bit of room for a margin of error, right? The attorneys will ask you, is it possible that this could be looked at differently? Yes, it's always possible. But is it probable? Probably not, depending on the circumstances. So you always want to leave the room, like if the technology changes, if the tools you used had some bugs that you find out 2 years later, and you need to correct your testimony, or you need to opine on something that may be similar, you want to leave that room out. So whenever you're writing a report or you're providing the testimony, you don't want to say this is the only way it can happen and not any other way that's possible. So always leave the room for the recovery and exit. Some other things that I wanted to share, if you have time, is when you're selecting a digital forensic expert for testimony work, these are some of the things to keep in mind. So in the US court systems, on some very large investigations, very high dollar amount cases, law firms tend to hire two types of experts. They both will be digital forensic experts, but one team of experts will only do the actual work. They will collect the data, they'll do the analysis, and they'll present the findings. Then there will be a testifying expert who will only look at the results of the consulting experts and testify about it. And their role will be, this is what I was provided, this is what I think is true, and this is my testimony about it. I'm not sure if it's very common in India or not, but this is one of the key factors. Also, if you are retained by the in-house counsel, the HR team, the chief compliance officer, or are you retained by outside counsel, outside attorneys on behalf of the company? because the issue of privilege becomes very critical. Any communication in writing or verbal, if you're working directly with outside attorney, becomes privilege and not discoverable. Any communication you do with internal counsel or HR people, then that becomes easily discoverable. So the other side can request those records easily, and you have to produce it. So if you are having any internal discussions about any particular issue, let's say HR issues, then those becomes easily discoverable. Something also to keep in mind is if you're looking for individual experts, sometimes some experts I've seen work as a part-time. They already have a full-time job, maybe something in law enforcement or the government, and then on the part-time they do, because of they have so much experience, they work as a testifying expert. So depending on the commitment that's needed for your case, you definitely want to keep that in mind, whether you need somebody who can spend 20 to 30 hours in a week, for how long, and is it applicable to your case. And the last thing I wanted to share is the overpromise and underdeliver. There are digital forensic experts who will say yes sir or yes ma'am and take on the work and agree to whatever you want them to say. But when it comes to the case itself, it can eventually harm you, because you want to hire the expert who will stand up to the facts and not just say what you want them to say. You don't want to get blindsided by something that the other expert will pick up very quickly, or the judge will say something that may be relevant to the case and that you are blindsided about it. So it's very important that you retain a digital forensic expert that tells you how things is, even though you may not like it. So I know I talked a lot, so any questions?
I have one.
Yes.
In the U.S. courts, how is the judiciary, how tech-savvy is the judiciary?
It is much more tech-savvy, I would say, these days compared to even 5 years ago. The judges are becoming more and more active on e-discovery and forensics issues. And more recently, I've seen the judges who, let's say, admits that they are not tech savvy. They would appoint their own digital forensic expert. So just to get to the bottom facts, like to give an example, we worked on an autonomous car driving litigation that was very complex. Both sides have 2, maybe even 3 digital forensic experts on both sides. And the judge is like, what am I going to do, right? So he hired his own expert and team of experts and say which side is giving more facts. Yep. Yep. Thanks, everyone.
So thank you very much for sharing your US experience on digital forensics and digital evidence. So I would request Atul Pandey sir to please present him the memento.
Okay, already as we are running short of time, and that's the best part, when you're on the end of the speaking slot, you can just sum up a lot of things. Firstly, I would like to thank Vishal and Nitin, Ashish, and Mr. Shastri. They have covered most of the facts which I would like to cover, but I would just like to supplement their thoughts, because in forensics, as all of us those have actively worked on live cases, like for me, for last 2 decades, yes, I have worked in forensics, but mostly in the law enforcement domain. And for the last few years, I'm working, you can say, in some kind of a corporate domain. And for last 5-6 months after my retirement, I am into proper corporate environment. So with that as a backdrop, let me tell you that 70%, this is not a calculated figure, but 70% time in forensics we fail, and 34% time we succeed. I would like to just add on to each one of the speaker who spoke before me, like Mr. Shastri said about ransomware, and I totally agree with him when he says that the crux nowadays is more about network forensics. If you don't have the capability of network forensics, you're not there. I would like to add one more statement to that, since that topic, my topic is on smart cities. In addition to network forensics, which is much, much, much important, I also say cloud forensics also plays a very important role, right? Because everything with the IoT devices coming into play, everything is going through the network to the cloud. So that is how smart cities will affect the forensics in the near future. Then coming on to Nitin also covered a wide range, and of course of chip-off and other kinds of technologies, ISP. And then he said chip-off technology may not work in near future because some devices may support. So it's better you go to JTAG or ISP. Again, I come to there with correlating with my topic, that when IoT and IoT will be, or Industry 4.0 will be working, in that scenario, again, I say only maybe to some extent JTAG and ISP will work in addition to the network and the cloud forensic aspect. So when we speak about smart cities, everyone knows what smart city is, because we are actually sharing the resources, making the lives more simpler, and we are getting increased interconnection and information sharing. And we are using the physical infrastructure which is there in a more efficient manner, so that everyone use it and in a secure manner, I'll put it that way, right? So you have a lot of services which are being, or solutions which are being provided or which are to be provided in a smart city kind of environment. For example, let me say, if it is on the screen, it can, okay, it's not visible. So basically it may be you can say a smart vehicle management system or smart parking kind of a scenario. I have a screenshot of the, you can say, Indian government smart city portal, right? See the various initiatives which have been displayed, and some initiatives which have already been implemented, right? Some initiative, like if you see, there's like smart water meter data solution has been implemented. In some places, you can say land records have been digitized. In some places, there's some kind of digitization or automation which has been already carried out in the way to meet the smart city kind of environment. Just a small, although it's an old example, but somewhere in 2016, we had a first or one of its attack in kind of a smart city kind of environment, in which there was a distributed denial of service. Here in smart city, availability is the most important thing. So distributed denial of service, or you can just block a service or disrupt a service. So that is one of the most important, you can say, threat vector, which will be used to actually disrupt this particular kind of environment. And in this case, you say heating, you can say heating devices were closed. One more important aspect nowadays, or there have been cases of smart cities, smart meters or smart grids being compromised, or infections, or you can say malicious lateral movement, what we were just referring to, happening with the help of smart meters, because they are updating themselves from one meter updates the other meter. So the content, you can say the extent of, you can say, lateral movement, because of the smart city kind of whatever technology and whatever architecture is going to be implemented, it will play a very important role. There was an attack even in Germany, and again, the BAS, the building automation system, was infected, and it was out. I mean, most of the, you can say, our 100-odd devices were out. So there are nowadays case studies which are there, which reveal that there are attacks on cybersecurity kind of environment. In India, at least, you'll not, as on date, you might not find a full-fledged kind of a cybersecurity, smart city, sorry. So, but there are few reports which have come up. One of the reports says that 40% of systems of smart buildings were, attacked, right? But out of that, only 26% came from the internet attacks, and most of them, means like 10% came from the storage, 10% came from phishing links, 10% came from shared folders. So you can say the attacks which are possible, or which may come in case of this kind of environment, may be from different devices. And the most important factor is the IoT. Now, when this is kind of, I'll not say it is exact, but this is some look-alike, you can say, diagram. You will have different services, data will be collected, data will be stored at a central place. There will be some computational, you can say, analytics happening on it, and then it will be served to our, the people who are running the government official or city planners as such. So if you see, this is one kind of a, you can say, smart city, you can say, architecture, although it is very sketchy. But now coming on to legal challenges, already Vishal has mentioned something from the US perspective when he's speaking of expert witness, but legal challenges may be covered in the Moot court also. But yes, we have a lot of issues when it comes to legality and forensics and smart cities and when we speak of networks. Now let me tell you, when I just intentionally mentioned my experience of 20 years in the law enforcement, the reason why I mentioned this was because till date only dead forensics was considered as a main, you can say, forensics activity. Network forensics was never considered as an activity. Only it came into place only when there was an incident response which was happening, right? So regarding legal aspect, it will be covered later. Law, privacy, yes, if where the forensic data collection is happening, whether it's over a network as we mentioned, or if you can say the CCTV coverage over city, privacy will be challenged. We will have to, as the forensicators, we will have to address this particular issue. How are we going to go about it? What will be the law supporting it? So all this, I always call, or every one of us knows, forensics is a techno-legal field. You have to be technically sound and legally updated. Then only you'll be able to address a particular issue in this particular domain. So a lot of common threats, just skipping this, spoofing, tampering may happen. In a IR kind of a scenario, this is a tentative block. There may be some incident handling which is required where you are capturing the incident, again, in any of the form, in form of network traffic or in the form of some, you can say, containers and some kind of cloud or in some kind of, if there's a physical infra, that, and extraction processing, data analysis, and data intelligence. So this is one slide. Also, of course, I will rush through this, but there are a lot of kinds of logs which will be collected because the number of facilities which will be available in a smart city kind of environment, it is going to be a very complex architecture from the forensic or investigative point of view, right? So there's no one single standard model which can be applicable in the smart city environment because the variety of models, various operating systems which will be running. Like if it's an industry 4.0, there will be some robot operating system which will be running, which most of us may be not knowing what it is, right? So there is a lot of, you can say, firmwares. Since IoT is involved and other devices involved, there will be firmwares which will be there. I've just kept it ... but of course Ashish covered this particular thing and Nitin covered it, because once we are going to get into forensic angle, whether we'll go to the firmware level kind of forensics, is it possible for us in a smart city kind of environment? That we'll have to think, right? But I would like to flash few slides about, say, if it's a smart grid. Smart grid, you have some security threats, you have some data sources, you have some forensic data which has to be collected, the level of its requirement, and what are the challenges. There may be protocol vulnerabilities which are due to communication gateways. So what do we require? You look at communication logs. There are a lot of logs which will be required, but large volume of data analysis, how we are going to resolve that. Similarly, coming into privacy, when we go to industrial control system or industry 4.0, which will also be a part of that smart city environment. So in that, your usage log, privacy will be a concern. Eavesdropping, where the smart applications will be running. So there are a lot, in a smart grid kind of a scenario, there are a lot of security threats, source, and forensic data requirement. So how are we going to meet that kind of requirement? That has to be thought over. This is just this is actual photographs of a center of excellence for smart grids in VJTI Mumbai. I visited there, and Dr. Kazi, maybe he's one of the speakers. So we were discussing on how we can actually implement forensic readiness or forensic frameworks in this kind of environment, and so that we can be able to collect some data. So although we are working on this kind of environment, but you'll have so many you can say cyber physical systems involved in this kind of a scenario that it will become very difficult. Now coming on to building automation system, I just gave you two examples which are happening, and this nowadays buildings or infra which is coming, even the government buildings which are coming on, they have this. Okay, I'll just finish in 1 minute. Okay, I'll just rush through. So regarding to UAVs, again, because UAVs are part of this, I had written a paper on Industry 4.0. In that, UAVs and other aspects, robots which were being used were a part of that particular paper. I will just surely share it with the organizers. Coming on to smart vehicles. So you see, in every particular, you can say, service or a facility being provided, you will have security threat, data source, and forensic requirement. And it is so huge that we have to categorize it. Right, we have to categorize it. So what kind of, you can say, skill set and infra will be required to address this kind of forensic solutions is a thing to ponder. Now coming on to cloud, as I mentioned, after Dr. Shastri mentioned about network, I emphasize in smart city environment, in addition to network, cloud is very important. These two has to go hand in hand. This is about cloud forensics. IoT devices, yes, IoT devices are basically, as you know, they don't have any storage capability, so everything has to be pushed out. So how can this be implemented? That has to be seen. I'll share this presentation. Then regarding, okay, coming on to the evidence cycle, this is about Industry 4.0. There will be a lot of, cloud computing, IIoT, big data analytics, which is happening on that. And this aspect of robot operating system, which is part of the Industry 4.0. So how are we going to carry out forensics on this kind of systems? Coming on to the smart factory kind of environment where you will have, different kind of layers, human-machine interface. So in short, what I want to tell you here to sum up, because I've been just told to finish it. When we are addressing the smart city kind of environment from the forensic perspective, we have to include all the knowledge which we have on other, you can say, sub-branches of forensics, and we have to club it together. And we have to get some kind of solutions. But we will require much more support of technology, much more support of people with higher skill sets, and much more support of, you can say, the law. Because law and the legal perspective is very important. And I think the next topic or next, you can say, the interaction is on the moot courts, or I think there's one more speaker, sorry, after that. So thank you. Within the stipulated time given to me, I've tried to give my perspective about smart city forensics and some challenges. I will share the presentations. It can be given to the whoever requires. Thank you very much.
Thank you very much, sir. So now I would request Samir Dutt sir to please present the momentum of dark web forensics. To deliver this, I would request Mr. Deepak, who is Senior Cyber Intelligence and Digital Forensic Professional from I4C MHA. Please.
So the topic is on dark web forensics. I know it's a very interesting domain nowadays when you talk about any emerging technologies-based cybercrime. In this presentation, in this scenario, basically, I would like to cover the fundamental aspect, basically, which we are facing in real scenarios, in real enforcement agencies. We are not talking about anything which is talking in a very bigger picture, like, Interpol did this, Europol did this and all, but we're talking about the Indian scenarios, like what kind of cases are coming, as well, what kind of forensics indicators are there which can help for finding the information. The beautiful quote start with this. It's my favorite one. I always say, because my domain is from the forensics domain, so I would say, if a person is keen about the data, if you know exactly how to get data from the machine, from the computer, from the device, from the any environment, that is the beautiful thing. And for the same, it's required exactly how much you keen into the technologies, basically. It's not like the automated things where you find the data, you got the information, and trying to putting those things in any platform. So once the document have been posted online, the genie is of the bottle. We say that, yes, we have posted something on Instagram, we posted something on Facebook or something, and we deleted for a period. हम सोचते हैं कि delete हो गया, चलो ठीक है, we are safe. But while investigation, while attribution or finding those information from the police specific or any federal agencies, basically, things are there. So it depends on the technology, like how they are securing their data on the cloud, on their environment, basically. So the topic is again the padding for the attribution of dark web forensics. So again, when you talk about in Indian perspective, dark web, I would say Telegram, a medium. The main thing, initiate from that thing. So if you got anything from any platform, it could be any breach dot something, any accesses or any platform जहाँ से हम data collect करते हैं. Even though we get the data from any platform, like any social media platform, it could be Chipwire, it could be Discord, it could be Telegram, it could be any places जहाँ पे कोई handle से data हमें मिल रहा है. So crime जो है, intelligence जो है, forensics जो है, basically it goes from financial fraud to different angle. You can see from the slide, basically. We are talking about social media frauds, data breaches, ransomware, online phishing, hacking, sabotage, eavesdropping and everything. The question is like here, all are interlinked with each other. And when you talk about interlinking, it could be cyber crime, cyber terrorism, cyber warfare, cyber forensics, cyber, everything cyber. The main thing is called digital. The thing is called the data, basically, here. So like suppose I'm sitting here, I took a IP of DigitalOcean or something like that, or मैंने कुछ host कर लिया, and pretending myself as a person who is sitting at abroad. So something is like that, this is a scenario where it could be used any Tor, it could be used any software which can give different IPs. A simple scenario, a host machine having a Indian or Delhi based IP, but similarly we are use some sort of VM machines or a Raspberry Pi or something like that, and we do have Tor based exit node जहाँ पे हमें different IPs मिल रही है. Similarly, we have seen various incident जहाँ पे हम देखते हैं कि ये data leak हुआ dark web पे. We are talking about vaccines, talking about different entities, those who are claiming that they're the cyber security companies, even though they got stamped. It's about the code, it's about the thing, the vulnerability basically which you're talking about. Things are completely like this manner. You can see अगर कोई data leak हुआ है या breach हुआ है या अगर properly एक manner में upload है किसी surface web या किसी dark web पे, how the mechanism. Similarly, talking about the credentials which were leaked on dark web or on any platform, on a surface web. मैं ही कुछ लीक करके, if I hide something like that on any platform, I know that to maintain the anonymity I could use this kind of servers, this kind of machines. So things like that. The entire thing is about the information which is available on the internet with some sort of weakness or vulnerability. Cards, best, you can give any terms which is there. A fundamental snapshot from the online perspective. My question here is like how forensically we can help, what exactly the indicators, the footprints, artifact, what to study. Do we run some sort of imaging solution and we wait for the result for 2-3 days and we'll check that कि yes, ये data उसमें मिला या नहीं मिला. Is that the forensics? I would say again like, because when we read about certain trends, certain examinations, certain information, we have two things. One, जो होने वाला होता है और जो हमें हो चुका है. मतलब like the information, incident has been done. Then we're trying to do a forensics. Means like client place पे गया, then we did acquisition of the machines and all. And we try to do analysis without knowing the abstract and all. We just got to know, yes, some cartel was there. He was trying to use some CSAM activities. We have to find some pornographic or any illicit or any content. So that is a vision basically. So here the artifact, the multimedia file could be JPEG file. If you know exactly, apart from JPEG, what other image file extensions are there? Do we know about HEIC and different things, which is recently being used by different mobile or devices as well? So things are there. Trending perspective, all the threat hunters, threat mappers, basically, they try to collect the information from internet. These are the keywords. Do we know about these keywords? Do we know about the things? If you want to do a keyword searching, even though in a machine, things like that. Searching perspective, the Google trend. From the Indian specific, you can see the green graph, where it goes basically. Similarly, from the state perspective, we can see exactly from which state, from the ISP perspective, what kind of data is being searched through this globe. Things are there. For example, if they want to search some sort of ganja, a word called ganja, even though the spelling could be a person, G-A-N-G-A, G-E-N-Z-A, something. So it's very important, like what exactly we're searching on internet, on the machine. So automated tools sometimes they help. I'm not saying like they could have a strong ML or AI, basically they can search something, but even though sometimes we have to use our mindset or the manual intervention which is required for the same. Like this info, Discord, the channels on various platforms. So I've given a screenshot from a threat intel firm. They periodically monitoring things, what is happening in specific area, in specific week basically, कि कौन से नए channels create हुए, उनके क्या नाम थे, उनका trend क्या था, उनका narrative क्या था. Search engines के base पे forensics करना, search करना, these things which is already pre-indexed. If things are not indexed, it doesn't mean that things are not exist. We have to think from a manual approach. Like drugs, I search something, I got a store called Tom and Jerry. If suppose I'm searching something with the keyword base, do you think we get information? जब यहाँ पे टॉम जेरी नाम से चीजें बिक रही हैं, so we have to think from that perspective. So things have been changed. We have to be update. We have to be thoroughly. We have to go or get into these things which is there. Now coming to main slide. What my pointers are here when you're talking about the investigation and forensics angle. Investigation attribution. When we are from law enforcement agencies, we do investigation. But from a civil perspective or like a private, we do attribution. We try to collect the notes, connecting the points. Then we say that from the factually, we have this information. So हमने notice किया कि we have different things, surface web, Tor, team, TTPs, सबका amalgamation करके then we get a proper result जो हम बात कर रहे हैं. So point one is that the very well-known quote, without data, you are just another person with opinion. Nowadays it's a trend basically. I would not like to name those things, but still, I got this. But the actual thing is called manual hunting analysis of that threat actor, adversaries, what kind of things they are maintaining. अगर Stuxnet में यह source code है या इसको belong करता है इस country को, then we say like this. Similarly, when you talk about any modus operandi of any case, they are making a call through this software. They're trying to talk in this manner. उनका बोलने का लहजा, उनका chatting करने का लहजा, उनकी English, उनकी phonetics, उनका online Google Translate, multiple things are there. So sometimes things are not written in any book or any blog. It's a personal experience comes with an individual perspective. Tools are there, no doubt they are rocket science. They can do automate the things जो हम manual नहीं कर सकते. But इसके बाद, do we depend on these things, or do we have to do some manual analysis? Yes, they can parse, they can give information, but the information they can give you, you have to study, you have to find that exactly yes इस data में यह information में यह important है. Then we have to connect that node with some different node. So sometimes what is happening by default, things are there, automated commercial things are there, lots of flagship things are there, but some pointers which I have mentioned over here from a Windows perspective, like these are the artifacts which I pointed out, like these artifacts can help in a preliminary analysis if suppose you are not depending on a tool which is commercial. So maybe this can help like file system analysis, restore point, Windows registry. हम बात करते हैं ransomware की. हम जब ransomware को ये नहीं जानते कि ransomware अगर encrypt करके फिर delete करता है data, तो forensics में अगर हम retrieve करेंगे तो भी हमें encrypted data मिलेगा. So things are there. So sometimes they completely think like the forensicators are the magician, like they can do anything. So sometimes we have to fight with the technology basically. What technology is saying like this? Which strain is that? Which malware is that? Which particular family is that? What TTPs generally which came through? ये phishing attack हुआ या कोई content download किया गया या what exactly CNC maintain करने के लिए क्या server use किया गया, क्या mechanism था, क्या timeline था? So things are there. Exfiltration में उसने क्या data copy किया, PDF किया, XLS किया, what exactly is done? Operating system, browser, short links, event log, ये fundamental artifacts हैं जो Windows के हैं. These are the main thing. If we study thoroughly with this perspective, sometimes they may help those things. Now coming to main point, dark web perspective. What exactly dark web? What exactly things we are doing? We are trying to finding those things from a machine. So when you see the phase 1, phase 2, phase 3, without intervention of legal things, how could you? Suppose you got an IP. अब IP के बारे में आप कैसे पता करो? Without any legal intervention, without any proper procedure, how could you get the information like this IP belongs to this ISP, this ISP given to Deepak Kumar? So these pointers sometimes can help. So finding from a 1 to 2nd to 3rd level, that are some pointers which I think. So first one is like the real-time investigation, real-time. आप RAM dump करते हैं, suppose RAM नहीं हो पाया, RAM dump नहीं हो पाया, then what are the other files there? We should focus on the memory file, page files are there, prefetch files are there. They can give some substantial pointers. वो सब भूल जाते हैं. So things are there where we have to focus on these areas. So conviction rate can go like this. So we are focusing like crime is happening. Depending on IP and the basically numbers, apart from numbers and IP, बहुत सारी चीजें हैं. So forensics can help to finding those information into these manner. Point 1, data, for example, Tor forensics. Tor browser is there because we know that Tor is a platform where we can use internet to access those things. What are the Tor pointers? If suppose you want to talk about a tool called NCase, we talk about any Belka, we talk any magnet, anything, things are there. So those artifacts, those who can parse those information, are they collecting those information? Yes. But what kind of information? So things are there. Phase 2 is about connecting those information from internet. OSINT से हम कैसे connect कर सकते हैं? These are the information. Last is very clear about the CTI part. जहाँ पे हम legal, multilateral, AMLAT की linkage establish करते हैं, जहाँ पे हमें यह लगता है कि कोई data हमें foreign से लेना है. For example, the case which is actually happening that. Deleted data. Understand about the logical and deleted file. This really help in any sort of forensics basically. So the red part is basically Slack one. I have taken a screenshot of very old 4.2 version of NCase, but still things are there. Recovery of the data from a Slack area. For example, images there, JPEG file. Sometimes the attribution, the name of the file can give good information. Yes. Sometimes maybe the file is not able to recoverable. वो नहीं होता कि आप retrieve करते हैं तो बोलता file is corrupted. That's fine, but the file name could be summary और या फिर CV of Deepak. So it means that CV Deepak का उस pen drive में था जो उसने stole किया, चोरी किया, जो भी किया basically. So these indicators, these time frames sometimes give some information. Explaining this information in a quote or in a platform, that really makes sense as well in reporting perspective. Browser में person claim that yes हमने install ही नहीं किया. Sometimes maybe we try to do what? We try to use some portable tool on a ground without doing a imaging. Sometime before seizing the evidence, we try to run a keyword search. At least we can see कि यह name. जैसे name example लीजिए. Suppose करिए कोई victim है. Victim name is Swati. अब Swati SWATI, I'm using this example. अब Swati SWATHI. Swati is in South India. So sometimes keywords play a very important role for searching any information on a on this kind of investigations as well. So one example like this, a screenshot of the Tor browser when it was installed. यूजर ने इंस्टॉल कर दिया, ठीक है, रजिस्ट्री में मिला, कहाँ पे इंडिकेटर्स हैं, क्या फाइल कितनी मिल सकती है, दैट इज द पॉइंटर्स विच इज देयर. वी बेटर नो अबाउट द SQLite फाइल्स आर देयर, दैट कैन गिव सम इन्फॉर्मेशन अबाउट द ब्राउजर पर्सपेक्टिव, डेटाबेस पर्सपेक्टिव. Locations are there, you can see like under which folder, like it was not in C drive, it was in D drive, maybe some person used some external drive. Registries can give good information. Human, that's the beautiful thing. Nowadays, it's not only technology part, sometimes our relationship, our knowledge, our wisdom towards in this fraternity, or you can say cyber security, that can give good information, human perspective. These are the pointers which is there. Have you really gone through with these things? टूल्स ये सब बताते नहीं है, ये हमें मैनुअली करना पड़ता है. फर्स्ट एग्जांपल लाइक टॉर हिडन सर्विसेज वेयर यू कैन चेक. हैव यू थिंक अबाउट SSL के बेस पे रिवर्स चेक करना कि एग्जैक्टली इस फिंगरप्रिंट पे और कितने वेबसाइट्स क्रिएट हुई हैं. फॉर एग्जांपल SBI योनो लोगो है, SBI लोगो के पर्सपेक्टिव दे कैन चेक एग्जैक्टली हाउ मेनी फिशिंग वेबसाइट्स हैज बीन क्रिएटेड. अब किसी वेबसाइट का नाम ngrock.io.something, ngrock.io में कहीं भी SBI लिंक नहीं है, सो मे बी सम सेंसर्स और सम स्क्रैपर्स वुड नॉट वर्क. Sometimes that image-based reverse, favicon-based reverse proxy can help to find those information, which is really important. Shodan, no doubt. How to search, that is again the big subject. गलतियों से ही चीज़ें निकलती हैं. जब गलती होती है किसी मिसकन्फिग्रेशन में या कोई कॉपी पर्सपेक्टिव में गिटहब पे कोई जैसे अभी एक सोर्स कोड लीक हुआ किसी पर्सपेक्टिव किसी कंपनी का, सिंपली सो व्हाट इज हैपनिंग देयर, द इश्यूज विद द क्लाउड, द इशू विद द सिक्योरिटी, द इशू विद द कन्फिग्रेशन, डायरेक्टली लिस्टिंग, verbose signatures and badly configured. So these are some pointers which is there for to finding the information. Again, the same points for the web page analysis. Sometimes these JS file, JavaScript files also can divide this information. No doubt, attribution perspective, a single email can give good information like कितनी websites link हैं. A single IP can give good information like what are the reverse thing. Maybe SSL update करने के लिए इस बार इन्होंने domain tools का use किया. Maybe पहले उन्होंने Let's Encrypt use किया, उससे पहले किसी और का. So sometimes you check the history and the parameters which is there. Last and very clear, roles of OSINT. OSINT play important role. OSINT से भी एक important word है OSINF, जिसे कहते हैं open source information. We are dealing with word that is called open source information, not the OSINT. हम technological क्या scrapping इतना data मिलता है जो net पे हमारे पास basically. When we find कि यह data important, then only we can connect with the things. A image is there, a simple add-on we can use. We can check exactly these image link with what all things. My R3E is basic, very clear. Reconnaissance, record, research, enforcement, which talk about recon. If it is in development domain, may work in this one. You want to maintain a hierarchical or you can say archival data that makes things, and research, enforcement is there. So again, the last, very clear. If you say that ki solve nahi ho paya case, so think about this layer. What you have done, what you have find from any investigation. Forensics can give good information, but the thing is called the manner, the approach basically which you're trying to find thing. And the last and very clear, what required here, we required these all things. Again the same thing, LEAs, forensic team, professionals, legal team, then that can give those information. So done from my side. I know it's a very short time. I try to cover in the entire artifact and the pointers and the linkages, which is really important for the perspective of the same thing. Again, Telegram, I would say maximum cases are coming through this platform. I'm not pointing this entity itself because maybe they try to initiate some sort of thing, a leak, a handle from this platform, a sample or anything. But when you try to do attribution, you will get some linkages which is in dark web or in different platform basically. Thanks from my side.
So let me give a brief background. So disclaimer, we have intentionally created a few mistakes in the investigation, and it's no way, there is no need to attribute the real expert, whether Mr. Yashwant Kumar would be committing such silly mistakes. The intention is very simple. It's a simulation, it's not even educating, it's a simulation of what happens in the court. Because whatever you see in movies versus the real court, there is a huge gap. If I want to tell my own experience, the question asked by the defense advocate to me when I was deposing in some 2005 related case, how many files are present in Windows XP operating system? And you are expected to give a logical answer. How many files are present in Windows XP operating system? And the answer has to be logical. So I had to say no, I don't know. So, as I mentioned, some mistakes are intentionally inserted to highlight the admissibility of electronic evidence in the court of law. And the case background we are discussing today, it's completely fictitious. Comet Solutions Limited is a reputed fintech company that provides IT services to majority of banks in India. That means they deal with a lot of customer information. About incident, the IT security team of Comet Solutions observed some suspicious access to database servers which stores a lot of critical and confidential information. So the first response, on thorough analysis, it was found that exfiltration of more than 30 gigabytes of data, including the customer information, business details, which were confidential in nature. So it's about data exfiltration, unauthorized access to certain classified information, and its exfiltration, subsequent exfiltration. So the preliminary investigation, as we all know, no one wants to directly go to police. We instead try to do the investigation on our own. So same thing happened in this case also. The internal investigation team, which was capable enough, so they did the initial response. The security incident analysis by the complainant's team, that is a company, indicates that the data has been exfiltrated using the credential shetty.manjesh at comet.com. An employee resigned recently and who is on service period, notice period. So the corporate counsel, the legal counsel advised the company that the magnitude of the case is very big. You have to go for a criminal case. Okay, we can't handle on our own. So the internal investigation team, they provided all the information and they got an FIR registered. So this is the background of the case. And we have cooked the case in such a way that it covers everyone, the audience, be it a police, be it a corporate, be it an individual. What happens in the court? We are trying to simulate. It's not mimicking, it's a simulation. So what investigation was done? Let me quickly tell you. So criminal case was registered by one head constable. Necessary documents and data were collected. The investigating officer issued notice to the complainant company to provide the IT network infra and firewall logs, application logs, database logs, DLP, all sorts of logs. IO reviewed, IO is the investigating officer. IO reviewed the firewall logs and Active Directory logs in detail and identified a particular IP address that matched with the timeline. The ISP was identified here as BSNL. Notice was served under 91 CRPC. 91 CRPC is the production of documents to the nodal officer to provide the physical address. BSNL provided the address. The IO checked with the complainant. Initially, police always do that to match with the name. And the company failed to identify this guy. Then the warrant was obtained. IO requested the help and guidance of Mr. Shashidhar, who works at the cybercrime station as a technical expert. Mr. Shashidhar, along with his team, agreed to provide necessary assistance and guidance. When the team entered, they noticed that the address was a garment shop. It was completely non-related to the complainant company, with only one computer which was connected to internet. The IO questioned the owner of the shop regarding the case being investigated. He was completely unaware. At this stage, investigating officer decided to review the CCTV clipping. So in general, we have the CCTV clipping, which was installed by the traffic management center. The traffic police, they have the CCTV cameras at the signal or junctions. IO identified one person accessing the computer on the day of incident, and Rahul, the shop owner, identified him as his friend Manjesh. So complainant company identified Manjesh Shetty resignation, but he is on notice period. So the team seized the computer, which was in on condition on 16th April 2021, and returned to their headquarters. They also took the copy of the CCTV. The accused Manjesh Shetty was traced and arrested same day. So Manjesh Shetty is here only. His mobile phone and laptops were also seized. Permission was obtained from the court to send the seized exhibit to FSL for seeking opinion. a forwarding letter detailing the exhibits, the type of examination required, questionnaire, brief facts of case, copies of seizure memo were sent to FSL for further assistance. The seized items along with the forwarding letter was sent through a special messenger. FSL, they did their examination and submitted the report which gave the incriminating evidence, whatever incriminating evidence was there, that was completely there. And the report was in favor of the prosecution. That means that the incriminating evidence was present in the seized exhibit. Based on his recommendation, charges were filed, and now the court begins. Honorable Judge enters the court hall. I would request everyone to stand. Thank you, sir.
Reputed fintech firm has made a complaint to the police for unauthorized access to their servers, which stores sensitive personal information of the customers. The IO has
Can you give us some brief facts about the case?
much of it. So, Your Lordship, IO has investigated the matter, and he has brought the case before the court for the adjudication upon the admissibility of electronic evidence gathered by the IO. The case relates to the complaint filed by the IT company regarding the data theft. So, as the case has been, if Your Lordship is well versed with the case, with the facts of the case, then I'll proceed with the issue that has come
Here,
forward.
I think it's better if he can explain what his case is.
I do say in the name of God that what I shall state shall be the truth, the whole truth, and nothing but the truth. Please proceed. Sir, this is related to one data theft. So in this case, a complaint company has made a complaint and registered a case and investigated. During the course of investigation, I have collected database logs, application logs, web server logs, active directory logs, and data leakage prevention logs. Based on the database and AD logs, I found the credentials of one by name Manjesh is used for unauthorized access. Based on the firewall logs, I found IP address, and same thing is requested to the intermediary BSNL. So BSNL has provided the physical address. Based on the physical address, I identified the physical address which belongs to one Rahul running a Rahul Fashions. On inquiring Rahul, it is came to know that the particular computer used in that Rahul Fashion was used by one of his friend Manjesh Shetty. So I proceeded the investigation and identified Manjesh Shetty and seized CCTV recording and a desktop from the possession of Rahul Shettigar, and the laptop and mobile phone was seized from Manjesh Shetty, concluded the case, took the forensic opinion and collected all the information from the intermediaries and finalized and charge sheeted against one Manjesh Shetty. So based on the different charges including data theft, sir.
Defense or?
Lordship, this is a very interesting case. Interesting case from the point of view that there are certain recoveries being made, and there are CCTV footage and a computer from Manjesh Shetty has been seized. And CCTV camera recordings and desktop computers from the Rahul Shettigar has been seized. And there is a seizure of a laptop and a mobile phone also. So, may I proceed with the cross, Lordship? Sir, how are you?
So I'm fine, sir. Good morning.
Good morning. So, this FIR is registered by a police head constable,
Yes, sir.
who has no powers to investigate the offense under the Information Technology Act because the powers has been primarily given to the police inspector. Can you explain to the court why this mistake was committed?
Sir, I'll agree with your point, but the thing is, the 72 of IT Act enumerates and empowers to investigate the cases under IT Act. But with respect to the registration, as per section 20 of CRPC, head constable and above can register a case in any act, sir. So as per that, so he has registered a case, he is not investigated, and in the first case diary, he is handed over to the next investigating officer who is empowered under IT Act, sir.
So I believe that this handing over after the registration is duly mentioned in the case diary.
Yes, sir.
I would also like to know that the offense related to the data theft, which talks from a point of view of IT Act 2000, how come that you have invoked section 379 and 420 of the Indian Penal Code also? Because that will make the offense non-bailable. Why were IPC sections were included?
Sir, first and foremost, based on the complaint, written complaint, the sections attracted and to make the case stronger, so you have included in the FIR stage.
Okay, but don't you think that IT Act being a special act, and if you are including the Indian Penal Code, even if it is a non-bailable one, bail will be granted primarily on the basis of that, yes, it is a IT Act main provision as such. So, and if you recall, there is a Sharat Digumarti's case where the Supreme Court has held that if there is an interpretation of a special law vis-a-vis the general law, the special law will prevail. So, I would just like to know that in view of the opinion given by the Supreme Court, whether any such mistake being done at your end.
Sir, I was not aware about that particular citation, and based on the facts of the cases, the case was registered and investigated.
Okay. Lordship, I would just like to submit here that the charges against my client should be dropped under the Indian Penal Code because those provisions of Indian Penal Code were added in a post-haste manner. Such provisions have no such locus standi in the eyes of law, and the person who is being asked or who has been referred that he has committed an offense, now he is also being charged just as he has admitted himself under provision of the Indian Penal Code, when such kind of provisions do not make any sense at all. Lordship. Lordship, there is also issue of section 72. Now, section 72 has been invoked in this particular case, and if I look into the statute book, then section 72 is not to have been invoked in this particular case because the kind of details that have been placed before this honorable court. Because section 72 talks from a point of view of breach of confidentiality and privacy. So section 72 should not have been invoked. I will just place before this court that what section 72 is all about. If you could just hold on a second. Yes. Oh, okay. Lordship. I will just take the code to section 72. It states penalty for breach of confidentiality and privacy. It is a saving provision, save as otherwise provided in this act or any other law for the time being in force, if any person who in pursuance of any of the powers conferred under this act, rules or regulations made thereunder, has secured access to any electronic record, book, register, correspondence, information, document, or other material without the consent of the person concerned, discloses such electronic record, book, register, correspondence, information, document, or other material to any other person shall be punished with imprisonment for a term which may extend to 2 years, or with fine which may extend to 1 lakh of rupees, or with both. Lordship, if we just look into the pith and substance of section 72, it talks from a point of view of if any person who in pursuance of any of the powers conferred under this act. If I look into the IT Act, then the powers which have been conferred, there are only certain statutory authorities like controller of certifying authorities, like computer emergency response team, authorized officers under section 69, 69A and 69B. So all these authorities have been given powers under section 72. Such thing cannot be invoked against a private individual who has been named as an accused in the FIR.
So your objection is that 72 could not have been invoked?
Yes, Lordship.
Because he is a private person, he is alleged to be an employee of the company.
Yes, Lordship. Yes,
Had
Lordship.
it been the IO who has disclosed this information to a third person, then 72 could have been invoked against him, and not against the...
Yes, Lordship.
Okay.
So the point is that had this disclosure came from, let us say, an investigating officer himself, then yes, that it could have been invoked against him, but not against a private individual.
Yeah. I'll take a note of it.
Lordship. So in view of my submissions made, I would request that section 72 should be dropped against the accused person. May I continue with the cross? Sir, you have mentioned that you have seized the CCTV recorder and the desktop computer from Shettigar Fashions, which is run from residence of Mr. Rahul Shettigar. Since it is his residence, you should have obtained search warrant from the court. How come no such search warrant has been obtained from the court when you have went inside, seized the material and arrested the individual?
Sir, I'll agree with your point, but the thing is, where I have seized this particular electronic gadgets, it is attached to the Rahul house, but it is not exactly the house. It is a public access place. He is running a fashion garment. There is a public access. So that particular computer responsible for unauthorized access was found in his fashion, that is Rahul fashion shop. So therefore, it is nothing but indirectly, it is a public place. So I have followed all the CRPC procedures and I have seized and documented and videographs.
Sir, have you also seized certain invoices where the name of Rahul Fashion or Shettigar Fashion has been mentioned, or where this address is mentioned as a kind of an exhibit for the court?
Yes, sir. What I have done, I have collected the certificate about a trade license from the local authorities and I have submitted before the court, sir.
Since a charge sheet has been filed and you have issued memo to your subordinate PSI to go for search and seizure of electronic evidence from the accused. Is it correct?
Sir, as per CRPC section 157, I have powers to delegate to assist the investigation to my subordinate. As per that particular section, I have delegated, sir, and I have done that.
But is it not a fact, or I should say a statutory fact, that Section 80 of the IT Act specifically mentions that who can conduct search and seizure? It is clearly mentioned that officer of above rank of police inspector is only authorized to do so. Then under the circumstances, why your subordinate was authorized by you in complete violation of the provision of the IT Act to enter a premises, search and seize certain electronic devices? Lordship, in order to look into this particular matter, I would suggest that it is being a special act, Section 80, which clearly states that what shall be the investigating officer's rank. It has been completely violated in this particular case. So under the circumstances, any such, it is not registration of the case. It is search and seizure leading to investigation. Yes, this is what he has said.
So your submission is that section 80 being a part of special code, it will override the general provision of section 157.
Yes,
CRPC,
Lordship. Yes.
And a PSI could not have been authorized.
PSI could not have been authorized
to conduct the search.
to conduct the search and seize, because these are the elements from the point of view of the investigation. Sir, I have another question for you. I have gone through the documents that you have filed along with the charge sheet, and that relates to the seizure of digital evidence and their subsequent analysis by FSL. But I have not seen any documentation regarding the hash value, or like which you can call is a kind of a digital fingerprint. I am not seeing any value like SHA1, SHA2 or something of this nature. Could you explain this?
Sir, first and foremost, my humble submission before the court is, hashing is not a mandatory provision. It is not, nowhere it is mentioned in any statutes. It is only a best practice. Depending upon the external and internal situations and factors at that particular time, based on the available resources during that time, so I have taken an initiative to seize without hashing. That is not a fault side. It is only a best practice. And the second thing is, I have procured the local witness, I have conducted merger, I have documented each and every step, and same thing is documented through videograph and produced before the Honorable Court along with the charge sheet for the perusal.
Lordship, here I just want to add one thing. It is merely recording of, it is a video recording of the individuals present and this entire process of search and seizure. But without conducting any hashing, without conducting any evidence which is admissible before the court of law, the entire process may not be taken a kind of a prima facie evidentiary value.
Sir, I have recorded, I have given notice to the local witness, and I have recorded, merger was conducted at this place, and in the merger, I have taken the geolocations and even enabled geo-GPS photography and videography. And the same thing, the chain of custody form is maintained manually.
Okay, but the question is whether you have obtained any permission from the court while conducting all such processes like creation of forensic image copy of seized HDD or a mobile phone, have you taken permission from the Honorable Court in order to conduct such kind of a practice?
So I have used a write blocker to create bit by bit encryption forensic copy, and it will not affect the integrity of any digital media I have seized.
Okay. But the hard disk drive integrity, as you have just mentioned, can be maintained by use of a write blocker, right?
Yes.
But can mobile phone be write protected? This is a question which I feel the court may have to look into. Lordship, regarding this particular issue, I would like to submit that standard operating procedures which should be there and which should be part and parcel of every search, seizure and investigation, and which should be a part of their rule book in a form of a best practices, they have not been followed. So whatever material that they have seized, the material that they have investigated, I'm putting a big question mark on that, and I'm also stating that those devices, they do not belong to the accused. So,
Thanks. Thank you. It is actually.
I swear in the name of God, I speak truth, nothing but truth. I, Krishna Shastri, son of Mr. Veerabhadraya, working as currently forensic scientist in FSL, Bangalore. I joined the government service in the year 1990 and I completed 22 years of service, and in my service I examined more than 2,500 cases and deposed evidence in various courts of law. The exhibits of this case was forwarded to my laboratory by letter number ABC dated 15th June. The same has been handed over through special messenger deputed for this purpose. The letter was addressed to my director, Mr. ABC. The same has been allotted to me for the purpose of investigation as per my organization's procedure. The exhibits of this case includes one laptop computer and one CD consists of log files related to Active Directory, log files related to firewall, log files related to web application server, and log files related to database server. And also 2 mobile phones, and having the model and make which are marked as Q1, Q2, Q3 by my laboratory. The analysis of these exhibits has been completed as per the standard operating procedures and the work procedures of my laboratory, which is an NABL accredited laboratory. And the analysis was also conducted by me as well as my colleague independently, and we came to the same conclusion. The report along with the exhibits was forwarded to Superintendent of Police CID Bangalore, via our office letter number so-and-so, dated 15th June, and a special messenger has been deputed for the purpose of collecting the exhibits. So the outcome of this particular report says, the computer system which was used for accessing the database and the DLP logs clearly showing a 30 GB of the data has been downloaded. On the basis of analysis of the firewall, we came to know a particular IP address through which the database server has been accessed. And on the basis of analysis of the application logs, the attacker are used a specific user ID in the name of Manjesh Shetty for accessing the database files.
Lordship, the forensic examination conducted by you, was it on original media or on the copy that has been retrieved and sent across to you for forensic examination?
The examination has been done on the forensic image. As per the cardinal rules of forensics, one should not work on the original evidence as the date and timestamps of the evidence will get changed. Keeping the best practices and the standard operating procedures that has been adopted by my laboratory, I forensically imaged the hard drive, and every analysis has been carried out on the image but not on the original
Not on the original, but on the copy.
copy.
Right. And I would just like to mention to you one fact which was evident from the documents which were part of the charge sheet, that the Caesar memo says that the IO has found that the computer system was on during the raid on 17th November 2022. But you have mentioned in the report that the computer was last shut down on 16th November 2022. How could this be a possibility?
Right. When I did the forensic analysis, I did the analysis of user-created files as well as system-created files. Especially the system-created files is nothing but the registry. Registry of the computer system is going to maintain who is the owner of the computer, how many people have logged into the computer, at what time the system was on and what time the system was shut down, and all the details are available as per the registry information. The date which I have given as 16th, one day before to the Caesar memo, is on the basis of analysis of the registry. So 16th is the date on which the system was last shut down, but the Caesar memo is showing as 17. The discrepancy is due to the 16th is the time when the computer system was a proper shutdown. The proper shutdown is a situation where the computer, the user will go to the log off mode, and if he shut down, that is called the proper shutdown, where the operating system has been shut down completely. But what the IO could have been done is 17, when the IO visited the crime scene, the system is in on condition. IO has simply shut down the system without going to the proper shutdown. So that was the reason why, remember, the computer is showing us a different dates. So 16th date is where the computer system has been shut down with a proper, that's where the operating system is maintained, the actual shutdown of the computer system.
Is it a fact that the date, the month, and the year has been mentioned, but there is no mention of the time? Do you think that in the Caesar memo of this nature, a time should have also been mentioned?
As a best practices, yes, but it is IO who should maintain that. As far as forensic is concerned, the exhibit has come to my laboratory and all my findings are on the facts that are available in the computer system. I have no idea about what the IO could have been done at the scene of crime.
Lordship may take a note of this fact that although the dates have been mentioned, but no time. So there's from a point of view of a time stamp is missing. I would just like to ask you one simple question. I'm not going into the technical details of it. The tools that you have used and deployed to test your findings and analysis, I'm of the view that the results produced has no validity. Though you have said that you are a NABL accredited one, but what NABL accreditation has to do with the validation and testing?
Okay. So it is not true to say that the tools are used are not validated. All the tools which are going to use it for the purpose of forensic examination has been tested on test cases for the repeatability and the reproducibility of the results. Basically, the cardinal rules of computer forensics says one should not work on the original evidence, and every tool which are using it for the purpose of examination, if two different parties have used the same tool, they should come to the same conclusions. So the main purpose is to eliminate the objectivity. Here it is to bring it objectivity and to remove the subjectivity factor. All the tools which are using it has been done at test cases, so that whether really they are producing a repeatable and reproducible results or not. So based on the test procedures and the standard operating procedures we adopted, the tools which have used it is completely producing a repeatable and reproducible results.
Is it correct to state that the tools deployed and used by you are not licensed one?
No, it is not true to say. We follow a standard operating procedures being a Government of India laboratory. So all the tools that has been procured and that has been used in the laboratory has been licensed to the director and the laboratory. So there is no pirated tool or outdated tools has been used for the purpose of examination.
Then the question arises, are you competent to give this report or to sign this report?
Yes. In my chief, I have explained you, I did Master of Technology and I have examined more than 1500 plus cases. And I did also specialized courses in the area of cyber forensics. And I feel that I am competent enough to examine and give the report to the Honorable Court.
But nowhere and no such record has been placed that your laboratory, FSL, is recognized by the central government as an examiner of electronic evidence under Section 79A of the IT Act.
Yes, my laboratory has not been declared, but it is under process of getting notified as a government examiner of digital documents. Recently, the process has been started in the Government of India and few laboratories has been accredited. So my laboratory is currently as NABL laboratory and we have applied for the accreditation in the form of a government examiner of digital documents, and this is under process currently with the Government of India.
That means, and which I would submit before the court, that means when this examination was done by the honorable scientist present here, no accreditation has been given under Section 79A of the Information Technology Act. Sir, I have...
Your Lordship, prosecution would like to make a submission. Your Lordship, prosecution would like to make a submission with regard to 79 at the later stage of the argument.
Okay, you note down this one, you can respond to it.
Please. I have also noticed from the documents which were part of the charge sheet that you have not provided any Section 65B of the Indian Evidence Act certificate, which has been made mandatory by various directions issued by the Honorable Supreme Court.
The certificate under Section 65B of Indian Evidence Act will not arise in my case specifically because my role is only limited to an examiner and I have no ownership or in charge of any data that is currently available in the hard drive so that I have made any tampering or I have added anything to the existing evidence.
So when you have said that you have examined the copy, you have examined the copy of the digital artifacts, at no point you have made the copy at your end, or the copy was created by whom?
The copy was created by me only,
Okay.
but the original hard drive using the software and hardware blockers are replicated, but I have not added anything or deleted anything from the suspected media. So what was IO has been forwarded to the seal cover to my laboratory, the same has been analyzed by me. So I can authenticate it, no tampering of the evidence has been happened.
But a copy was created by you,
Yes.
and you have examined that
Copy.
copy for your analysis.
Correct.
Lordship may take a note of this, that the Honorable Forensic Scientist has placed before the court the facts that the copy was created by him, and on the basis of analysis of that copy, he has made the following submissions which have been made part of the charge sheet. I have no further questions. Thank you.
Thank you.
Your Lordship, I would like to submit that with regard to Section 79 provision of Section 45 of the Indian Evidence Act should be read with Section 293 of CRPC, empowers the Honorable Court to admit the evidence presented by the forensic scientist.
Commission is an expert witness. May not be from an accredited lab, but he is to be treated as an expert.
Yes, Your Lordship. Now, the forensic scientist has done exhaustive analysis of the seized digital media and has collected necessary information to prove that accused person had access, control over the seized exhibit. This is established by the advanced registry analysis, which has recorded the username as Manjesh123. Further, the email analysis of the offline OST files gives enough evidence regarding the accused person's email ID, which is linked to his bank accounts, which conclusively proves that the computers and other devices belong to
So as per
the
you,
accused.
whatever email ID was recovered from there, it is also used by the accused for his bank account also. Same email ID is given in his bank account also.
Yes, my lord, that is the revelation of the forensic examination.
Lordship, here I would just like to intervene. They are relying upon the CCTV footage also. CCTV footage which they have captured and which they are saying that a face has been seen. One of the witnesses has recognized that this face is of that of Manjesh. Lordship, the point is the CCTV footage, the device from where this CCTV has been taken, they have taken the copy of it. They have not taken the master, the master original, and they have not noted down the CCTV serial number of that particular device, which they should have. And also, we do not know what is a record retention policy of that premises from where that CCTV footage has been obtained. So it is a prosecution witness which is recognizing Manjesh. And we all know the kind of grainy pictures that CCTV footages do have. So we have no, I should say, there is no corroboration of this particular fact, whether the accused was there, was seen on that particular date and time.
Your Lordship, it would be inappropriate to question the relevance of the evidence which is already admitted by the Honorable Court. The defense had not had the opportunity to object during the marking of the evidence. Also, it is pertinent to note that footage were captured by the device which is owned, operated and managed by the public authority, and that is City Traffic Management Center. There would be significant impact of device containing footage if it is if the original is taken and taken to the custody of police and presented to the court, then it would have bearing on the other evidences which would be available in the City Traffic Management Center, because it stores the data of the entire traffic system for more than 8 months. And hence, the IO decided to collect the footage along with the 65B certificate under the Indian Evidence Act, and which is the part of the best practices in relation to electronic evidence. Further, IO has issued preservation notice in charge of the traffic management system, so that if the defense may like to examine and verify it with the original evidence, that is with the City Traffic Management System. Yes, yes. Much obliged.
Lordship, my learned friend has talked from a point of view of a Section 79A, Examiner of Electronic Evidence. And in fact, they have also said that since we are looking into a Section 45A, read with Section 293 of the Criminal Procedure Code, so this expert evidence should be taken on record. Lordship, I have my doubts on this. Why I'm saying this? Because Section 79A is a special provision under the Special Act. And as us, Honorable Forensic Scientist has himself said that on the date of examination, no accreditation was granted to their FSL. Right, and Lordship, here I would just like to put across to you for the benefit of the court. Yes, Lordship. Section 79. Lordship, no, I'm putting across to you the list of 11 forensic laboratories recognized under Section 79A of the IT Act. Their FSL does not appear in those 11 recognized laboratories. And all these laboratories, if Lordship may notice, are being recognized for a particular work like mobile forensics, if Lordship may look into the footnote of it. They have not been able to place any record on their charge sheet or any document putting across that yes, it is a recognized one. So the entire evidence and the examination thereof may not be considered by this honorable court. This is my humble submission.
Yeah, Your Lordship, prosecutor submits before the Honorable Court that non-recognition of SFL should not be an issue, should not be seen as an issue. And I would like to cite few judgments that have recognized the state FSL under Section 45 of Indian Evidence Act, read with Section 293 of CRPC, 1973. One important judgment and very path-breaking judgment is K. Ramanujan Elias Appu versus the Inspector of Police, Chennai, 2016. In this particular case, the Honorable High Court had allowed the admissibility of the reports which were generated by the state, Tamil Nadu State Laboratory, Forensic Laboratory.
Lordship, here whatever my learned friend has just said, I would like to counter this. Because Supreme Court, in various judgments, when they have talked about the electronic evidence and its examination, they have talked from a point of view of standard of proof. It is, and this is what Supreme Court has said, standard of proof in the form of electronic evidence should be more accurate and stringent compared to the other documentary evidence. That's why Section 79A comes into play, and that's why various laboratories have been notified. This standard of proof as a ratio has been propounded in Tukaram S. Digol versus Manik Rao, Kukotke. And Lordship, there is another case where the court has said source and authenticity are the two key factors for an electronic evidence. So unless and until the source and authenticity is being properly verified and checked, and from the parameters of a designated laboratory, I believe, and I will submit before this court, that such kind of practice may not be allowed before this honorable court as such. So, Lordship, before I close, I wish to reiterate certain points. There is no documents that have been provided by the investigating officer to prove the ownership of the seized digital device. And I categorically state before this honorable court that the device or devices do not belong to my client. The state FSL admitted by the honorable forensic scientist in his cross before this court is not notified under Section 79A, and the evidence related to the CCTV footage is incomplete because the only footage is produced and the original evidence is not seized. While doing a forensic examination of the seized devices, no such permission was also obtained from the honorable court. And in the best interest and from the point of view of justice, I request that the charges against the accused person should be dropped.
Yeah. So before making the prayer, the prosecution would like to submit that there was no procedural lapses with regard to the investigation and exhibition of the electronic evidence, and also the standard operating procedure were followed, and the rules which are prescribed under the section 65B of the Indian Evidence Act, they were strictly followed and adhered. And in the case of, while making the Panchanama, the IO has taken full care and attention. In the light of the above, the prosecution would like to submit that before this honorable court, that issues raised and argument advanced, cases and authorities cited, it is most humbly prayed before this honorable court to hold the evidence produced before this honorable court admissible, to uphold the validity of electronic evidence under the IT Act 2000 and Indian Evidence Act 1872, and pass any such order, directions or reliefs that it may deem fit and proper in the circumstances of this particular case, and in the interest of equity, justice, fairness and good conscience. Much obliged.
Seen the evidence which has been recorded, documents which have been produced, and I have heard both the sides, the prosecution as well as the defense. The points which this court is called upon to decide are, in my view, the first one is that whether to admit the computer seized from the accused for which ownership is not established by the IO. This is the first point which has been raised by the defense. Second is, since state FSL is not notified under section 79 of the IT Act, the opinion given by the expert from state FSL, whether it should be taken on record or it should not be taken on record. Then the evidence related to CCTV is incomplete because only footage is produced and the original evidence is not seized, and whether it should be considered while deciding the case or not. Then the next point is that the mobile phone was handled by police directly without permission from the court, and whether it should be taken as part of the evidence or not. So the considered view of the court is as under. As far as the number one point is concerned, my considered view is that IO has taken help from the state forensic scientist to gather technical information to prove that the accused person had access to that device, and this evidence is admitted. The second point is regarding the opinion obtained from FSL, which is not notified as examiner of electronic evidence under section 79A of the IT Act 2000. Is still admissible because the reliance has been placed by the prosecution on section 45, being an expert witness, read with section 45 of the Evidence Act, being an expert witness, and section 293 of CRPC. But there is an advice to the central government to speed up the notifying of the labs all over the country so that they have adequate facilities and their evidence is covered under section 79 of the IT Act in future in other cases, because this objection will be raised by the defense in each and every case which will come before a court. The third point is regarding the CCTV footage. The evidence obtained from the traffic management center camera is admitted as IU has convinced this court for not seizing the original the footage as well as the device, and he has taken necessary precautions because he has issued the order to the concerned authority to preserve the original recording, and the defense could have raised an objection at the relevant stage, and the original footage could have been seen by the defense at that time. And the last point, I agree with the defense counsel regarding the mobile phone. The IO has failed to appreciate the handling of mobile phone, and this evidence is dismissed. So this is the final finding of the court. Thank you very much. I really thank both the counsel for the help which they have rendered to the court. Thank you very much.